Good day, everyone. Hey, this is T. Scott. I wanted to start a series on really esoteric things that are kind of important to you, right? And so for our inaugural event, I thought I would put something out that it's easily researchable online, but maybe this video will help make it a little easier for you to understand when you do your own research. So with that said, obviously I'm not your attorney. I cannot give you legal advice, etc. But this is going to be good. Okay. So there is a concept in the law called a holographic will. All right. So this is a will that it basically means a big word to mean just handwritten. All right. So there is a provision in the law that says, hey, you don't have to go to an attorney. You don't have to, make a big deal out of it, like, at the end of a movie where they read the will. No, you can simply take out a pen and paper and draft your own will. And what is a will? A will just means what I want done, my will, but it's actually a thing as well. So, okay, so let's talk about holographic wills. Why are they important? Well, they're important because you may not know this. If you have no will, it's going to create a lot of complications in your life, especially if you own real property, a home, land. If your state you live in is based on the common law, so that's going to be your states that were, settled by English settlers, non-Spanish areas, which is most of the east and the middle of the country. Then there's a concept called dower and courtesy rights. Okay. And so what does that mean for you? That means that if you die without a will, your property under the common law goes to your children. So if you have a spouse, that's not so good for them, right? Especially if your children are minors. So that spouse would essentially be living in property she does not own or he does not own. So that's not good, right? You means you can't sell it unless you know, typically get some sort of court order that that's the best interest of the children. So that's not good, right? What does the spouse get in those states? Only a 1/3 interest in a life estate. That's it. That's all the spouse owns until the day he or she dies. So it's pretty good to have a will, right? Especially in common law states. Now, that's different in states that were started out under Spanish colonization. Why is that? Because they have the concept of community property, which is, in my opinion, far superior. What does that mean? That means that any property purchased during a marriage is automatically one half the spouse's, automatically, right off the bat. So any money made, anything like that, it's one half the spouse's. So if one of the spouse dies, the other spouse gets 100% ownership automatically by law. You don't need a will, right? So under under states, that were under Spanish colonization, you have a superior way to go. That being said, let's talk about how holographic wills actually work. What do you need, and how can they help you? Okay, so let's start out by framing this a very famous case. So there was a gentleman. He's on a tractor. He gets in a horrific accident. He's trapped under the tractor. He's dying. Knows he's dying. So he takes out his knife and he etches into the tractor, "If I die, all to my wife." All right. And he signed it. He etched his name in there. Is that considered a will? Well, okay, let's talk about it. So holographic will, we know they can be handwritten. Is that good enough under the law? Well, let's look at 3 different states and come to a conclusion on that. So let's look at Florida. All right, so Florida, it has a law on holographic wills, and that law is you cannot have a holographic will. Sorry. If you're in Florida, put the pen down. Why do you think that is? A lot of older Americans, a lot of attorneys dealing with these issues. So, do they want folks writing their own wills? That's Scott Randall here. That's my opinion. I don't know what was in the mind of the legislature, but I can guess. All right, let's talk about Texas, where a lot of you are at. So, does Texas have a provision on holographic wills? Yes, it does. Does it allow them? Are they considered valid? Yes, they are. Cha-ching! So you're in Texas, you can handwrite your will. So what do you have to do? You have to handwrite it completely, every part of it. The testator or testatrix has to write it out completely. So what does that mean? That means that if you bought one of those pre-made wills out of a book in, let's say, Barnes and Noble, and you wrote out in the little blanks, you said, yeah, I want it to go here, here, here. That's not good, right? It's not completely handwritten. See that? See that? That's what you're here for. Has to be clear that it is a will, that you're not just writing some sort of memo for later use when you do make a will, right? So it's always good to put some sort of magic language on the top, like last will and testament. That's good. We'll talk about a couple other things, but you always have to show anytime you have a will, whether it's a holographic or not, that the testator, testatrix had sound mind and were not under duress at the time of making the will. So that's something you're going to have to show with any kind of will. Now, if you have a holographic will, what does that mean? That means that it's going to be hard to show that. Why? Because you have no witnesses. No one saw you make the will. Now, maybe they actually did witness it, but they didn't sign the will. Now, that could be, but that, in order to prove that, you have to go to court, right? And that's what you want to avoid because it's very expensive. So a holographic will, it's sort of, handmade for litigation. Why is that? Because you only have to write it out yourself. You only have to sign it. That's it. Nobody has to see it. Nothing. Now, if they do, obviously that's better. How do you prove that the person was not under duress at the time? I don't know, right? You're going to have to figure that out. If you have a normal will where you have two witnesses and they're both signing in front of each other and the testator, testatrix, that's a lot easier, right? So you got multiple people involved and they all saw the actions of the testator, testatrix. So that's easier. Okay, well, let's talk about California. I know some of you are in California. Does it have a provision on holographic wills? Yes, it does. Cha-ching, Florida. Same kind of formalities involved as in Texas. So it has to be all handwritten, has to be signed by the testator, has to, show an intent that it be the will, cannot be made under duress or when you're not of sound mind or under intoxicating drugs. See that? That's a catch. Can't do that either. Now, in California, if I buy that pre-done will where it's sort of fill in the blank, you get your crayons out and you're trying to go down the blanks and you write it out and you sign it, is that good enough in Florida? Yes. Cha-ching. So what does that do for your ability, again, to prove up the will? Well, it's a little harder because you didn't really sign that much of it and you didn't draft that much of it. You have less handwriting to show that it's actually yours. So you'd have to prove that in court, that it's your handwriting through all the little blanks, and even with the Texas will. So if there's any question in the validity of the will, you have to have a handwriting person come in. Yep, that's his or her handwriting. You have to have someone come in. Yep, they were of sound mind. Yep. All right, so let's get back to our guy with the tractor. So he's under the tractor. All to my wife. If I die, all to my wife. Okay, so Florida, is that going to be considered a valid will? No. You You don't have multiple witnesses. It's just not done with the proper formalities in Florida. That would not suffice. So what would they do in Florida? They would treat you as if you had no will. And they would go down the statutes of intestate statutes saying the person has no will. So the state actually does have a scheme out there where it tells you where the property is going to go if you don't tell everyone else. So keep that in mind too. Texas, is that going to be a valid will? Yes. Yes. Why is that? It's all in the testator in this case. It's a man's handwriting. He signed it. It's clear it was a will. He was dying at the time. Do you have to prove he was of sound mind? Maybe. Maybe he's, under duress. If there's a child out there that says, hey, I don't like this, that could be a question. Was he of sound mind at the time? But most likely it would work. California, would it work there? Yes. Drafted by the testator, signed, clear it was intended to be a will, and where the property goes is pretty explicit as well. It goes all to the wife. So we've just talked about holographic wills, why they are important, and a couple of examples on different state laws on how they treat holographic wills. So I hope it's been worth your time. Tune back in. We'll do another video. We'll have some fun. All right, peace.